Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, Bobby, it is great to be back with you today. And for our conversation, we're going to be focused on temporary orders and immediate relief. So as you know, when someone is going through the divorce process, there obviously is so many unknowns. And so why don't you sort of just talk us through, what is a temporary order or immediate relief, and why do people need it?
Thanks, Greer. Yeah. So a temporary order, really temporary orders and the need for a temporary order is one of the main reasons that we actually have to go to court sometimes. I talk a lot about staying out of court, trying to do this as diplomatically as possible, do mediation, do collaborative divorce, resolve it over the kitchen table. Don't go to court if you don't have to, but sometimes we do. And that's when maybe we're not getting to see the kids as much as we want, or there's some financial issue that's really important that it's addressed, and we need the judge's help. So the temporary order is where we go into the judge and say, Judge, we got a lot to figure out here, but immediately we'd like you to weigh in on X, Y, and Z. And that's what a temporary order is.
And what would maybe some of those X, Y, or Zs be?
Yeah, so the most common one is where the parties, you and your spouse, have separated. Maybe you decided to move out, you have a couple kids, and the kids didn't come with you when you moved out, or that was the agreement, is that they were going to stay and you were going to have be able to see them. But you and your spouse didn't work out the details. You just said, okay, you're going to be able to see them whenever you want. Don't worry about it. And so you moved out. But now it's not as easy as you thought it would be. And it seems to be that there's kind of always something else going on. The other parent is always saying, well, today isn't good. This weekend isn't good. And before you know it, you haven't seen your kids for 2-3 weeks and you're not getting anywhere. And you go, okay, I need to get into court and get a court order that says I get my time with my kids. That's really the number one most important time that we see temporary orders coming into play.
So tell us, what is the difference between a temporary order and an emergency order?
Sure. So a temporary order is for what I just talked about, more routine things where you two could probably figure it out. It's not, life and death, for lack of a better expression, if you don't figure it out immediately. The consequence isn't as severe. An emergency order is where if something doesn't happen immediately, there's going to be kind of irreversible consequences to it. And a good example of that would be, let's say the other parent has been telling you for a couple months that they're going to move out of state with the children. You say, no, you're not. I'm not okay with that. That's not going to happen. And then you come back home from work one day and they're gone and they've packed up and they have gone to another state with the kids. Or another one that we see fairly often, or not uncommonly, is that they say, you know what, I need some time for myself with the kids. I'm going to go stay with my parents for a couple weeks and I'll see you in a couple weeks. And they go to, Iowa to see their parents. But then after a couple weeks passes, they say, I'm going to stay a couple weeks more. And then it's a couple weeks more, and they just drag it on and on. And if you don't do something in court and they stay there, then all of a sudden you're incredibly behind the 8 ball as far as the case goes. The state might lose jurisdiction of the case, and your kids may never move back. And maybe they have school starting or something like that as well, and it's just imperative that they move back. That's the difference between something that's a temporary relief need and an emergency order type of.
Okay, my anxiety is literally like growing as you're talking about this, because I could imagine the stress that someone would feel. I mean, I'm assuming that this would also be something, maybe if you were afraid that maybe your spouse was going to take a big chunk of money or was going to freeze accounts for you. So there's probably a lot of different things can happen. And I imagine this is because of the timing, right? I mean, if you have an emergency order versus a temporary order, the emergency order is going to be processed faster. Is that sort of the point?
Yeah, exactly. And we'll dive into actually the process of temporary orders and how long those can take. But suffice it to say, there's 2 steps to an emergency order. First one is convincing the judge it's an emergency. You can call anything you want an emergency and present it to the judge pretty much the next day in court. Some courts say you need 48 hours, 24 hours, but it's very quick. And you're in front of the judge and you say, Judge, this is an emergency. First, the judge has to agree with you that it's an emergency. If they say this is not an emergency, then you got your SOL and you got to go down the route of a temporary order. If they say it is an emergency, then they're going to hear testimony, evidence, arguments right then and make a decision right then as to what happens. I mean, all the time we do these emergency orders and we get orders from judges saying that the other parent has to immediately return the kids to the house or has to immediately give the other parent some parenting time or establishing a schedule. So it's very quick as opposed to the temporary order process, which is a little bit slower.
Okay. And one more thing on that. Do these type of orders typically happen early on in a divorce, like at the beginning when sort of things are kind of unknown, or is this something that could happen at any point during a divorce?
It could happen at any point. I mean, it's not uncommon, though, that it happens at the beginning because, like I said, that is oftentimes what compels us to start litigation is that we have one of these issues. And so we tell our client, like, listen, if we're not able to resolve this by agreement, and usually our client says, yeah, it's not happening. My spouse is completely out of pocket at this point. They're not agreeing to anything. Then we do have to go. Then really the only resolution or the best resolution is us to rush to the courthouse and see how quickly we can get it done either via temporary or emergency motion.
Okay. All right. So let's dive a little bit deeper into temporary and potentially also emergency orders. And let's talk about situations where kids are involved. You said that this is very common when you're trying to come up with a custody agreement. So talk about kind of the purpose of having a temporary child custody, agreement, having that order. And what does that decision-making process kind of look like, because obviously they're trying to make sure that the child's best interest is in mind.
Yeah, so let's start at the end here and what we're actually trying to come up with, which is the temporary, what we call a temporary parenting time order. And what that order is going to say is, for example, father gets children Monday, Wednesday, and Fridays, and mother gets the children all the other time, or mother gets the children every other weekend, father gets all the other time, or vice versa. So that's the end place we're going to get, is this actual nuts and bolts order that tells us specifically what time each parent has, maybe where the exchange location is. In very volatile types of situations, we may set a neutral exchange location that the parties are going to exchange the children in some public place. Those are cases where it's gotten very volatile and neither parent feels good about going to the other parent's house. We want to avoid that kind of stuff because it is very traumatic for the kids, but we do the best we can in the immediate moment as far as what's needed. So that is what we're aiming towards here as far as the end goal.
So just to review, what you're saying is that when you have this temporary order, one, you're deciding where the children are versus like with their mom, with their dad, how much time, what days, and then also where the actual transition or the switch happens. So those are kind of the two main things you're trying to work out, right?
And also, I forgot to mention transportation. Who's going to take the child? Is one parent going to always do the pickups, or sometimes logistically both one parent has to do the pickups and drop-offs? But we're going to nail all that stuff down and make it crystal clear, because before we got the temporary order, you two couldn't figure it out, and you were just kind of getting in these conversations and it wasn't going anywhere. And so we're going to nail down all those particulars, put it into writing, have the judge sign off on it, and then you have to follow it. And hopefully that gives us a foundation so that we can figure out the rest of the case.
Right. And that's such a great point to mention that we are here now because the couple was not able to decide for themselves, right? So we have to always remember that this you could avoid this completely if the two decide on an agreement and stick with it. So let's say, but we know in this particular situation they were unable to. So let's really talk through those factors of what exactly is the court going to be looking at to decide, okay, well, they're going to have X amount of time with this parent, X amount of time with this parent. What are some of those key factors?
Yeah, so the overarching factor or standard is the best interest of the child. And then when the court looks at and considers what's in the best interest of the child, the biggest kind of concept in my mind that the court looks at is stability. What's going to give the child the most stability so that they can continue to excel in school, excel socially, continue to grow their bond with their with their parent, with both parents. So they're going to look at the whole situation and figure out what is most appropriate here. That is the number one thing, is stability. Now, one of the most important factors that they do look at is the status quo. What has been going on for the last 6 months? Who has been doing the heavy lifting as far as getting the kids to school, getting them home, making sure they do their homework, getting them dinner, putting them to bed? Like, who's really been the parent that's been really involved? So that's something to keep in mind as you look forward to the divorce process, and you want to make sure that you have the quote unquote strongest case. Is make sure that you're really involved. And this isn't like, you're strategizing for court. Like, this is just a good thing to do. I mean, kids need both parents involved, especially if the marriage is ending, and it's best for both parents to have that daily caretaking function, as it's legally called.
Yeah. Now, is the court going to appoint a primary caretaker, or is it potentially, are they joint?
It could be either. It
Okay.
could be either. And in some cases, the court will say, I don't see any reason why this can't be 50-50. The child really is best off if they have equal contact with both parents. In other cases, because of their relationship to each parent, because of maybe each parent's emotional stability, financial stability, emotional intelligence, like all those things play a part, the court might say, the kids really are better off if mom or if dad is the primary parent, because they provide that stable environment so the kids can continue to go to school, continue to have time with their friends, and feel as little disruption as possible. It's a balancing act.
Sure. And so if a parent disagrees with, let's say that the court does decide, hey, mom or dad is going to be the primary caretaker, and the other one disagrees, is there anything they can do in that time? Or basically, do you just kind of need to accept it, and then you're trying to make a change for once you go to court?
Sure. So if the parent disagrees, let's say we're in the context of we've filed a motion to establish that parenting schedule, and the judge is making their decision, and the other parent is saying, I don't agree with what the mom wants, or I don't agree with the dad wants. At that point, the judge could do a couple things. They could say, well, this is only temporary, so I understand you don't agree, but we need something in writing. Or the judge could say, you know what, given the level of disagreement here, we need to get a guardian ad litem involved. We need to get that person. And a guardian ad litem, as we've talked about before, is that attorney that's appointed to represent the best interest of the child. They're kind of an investigator. They give recommendations. So a judge may do a temporary schedule, or they might say, you know what, I want a guardian ad litem to give me a little bit more information about what's going on before I make this decision.
Right. Okay, so we've covered a lot on the on the custody side of things, and I'd love to shift to talk about finances. So another area of big concern and uncertainty when people are going through divorce is the finances and how that's going to work. It could be that both spouses are working. It could be that one is the main provider and the other has been home taking care of the kids, or there's just a big, difference and, what the different spouses make. So can you sort of talk about when and we're talking about the temporary orders. So for that temporary time when you're trying to figure out the divorce, how does it work when on the financial side of things?
Yeah, well, let's say that you are not the primary breadwinner and you've taken care of the kids while your spouse has progressed in their career. And that was a great arrangement when you guys started your partnership and it really worked. But now that you're getting divorced, you're really worried about how are you going to pay for things and how are you going to support yourself financially? So you need to go into court and ask and file a motion for either temporary child support or temporary spousal support, also called alimony, also called maintenance, and ask the court to set a temporary order that you get X amount of dollars per month. And those amounts are generally calculated using a formula. So as attorneys, we can tell you approximately what you should expect to get. But that is really the best course of action if you are behind the eight ball financially.
Yeah. And it makes me think with either, if you're trying to figure out, the child custody situation or child support, alimony, the financial situation, how long does it typically take to get these temporary orders?
Yeah. We tell people that if they need money immediately from the other spouse, one thing to understand is it's not going to be an emergency. The court will almost never, like 99.9% of the time, say this is not an emergency. So we tell our clients, you're going to have to get some assistance. If you truly need money immediately, you're going to have to either go to family, friends, a bank, use your credit card, whatever it is to just make ends meet, because the process is going to take probably 3 to 4 months from the time that we initially file the divorce until you get that order from the court saying that you get $1,000, $2,000, $3,000 a month, whatever it is, and that's based on your spouse's income and your overall financial situation.
So, Bobby, can you break down the process of one, what does it look like and how long does it take to get these temporary orders?
Sure. So if we're talking about getting child support, for example, what does that look like? Well, the first thing that we need to do is file the divorce. And with the divorce, we'll immediately file a motion for child support. But if we look at the actual deadlines and the length of time that each stage takes, we can see why it might take 3 or 4 months. So, for example, we file the divorce, we get the other side served. They then have 30 days before they have to do anything. So there's like a 30-day waiting period at least. We can then go into court and say, okay, judge, we'd like to present to you our motion. And presentment basically just says, judge, we want you to give them a deadline as far as responding. And that deadline is usually another 30 to 45 days. And then the judge will set it for hearing. And that's where the judge actually makes the decision. And between all these court dates, we also have to exchange some initial financial information. And if the other side isn't cooperative in doing that, there might be yet another delay. So we'll keep pushing to make sure it goes as quickly as possible. But just by virtue of those mandatory waiting periods and customary waiting periods, we're looking at a 60, 90, sometimes 120 days from the filing until the judge doing the hearing. And the hearing is what ultimately results in the judge signing an order saying that the other parent has to pay you $2,000 within 7 days, which is ultimately what we want, is that key order saying, you have to give this person money within 7 days, and then we actually have something to work with.
Okay. Whew. Okay. Well, it's good to set those expectations of what exactly it's going to take, and that, it is going to take a little bit of time. And another area I feel like of concern, especially when you are first going through a divorce, is the marital property and specifically your home. So how does it work in the state of Illinois for, maybe who takes possession of the home? Can you take possession of the home? Sort of break down that for us.
Yeah, we get asked this question a lot by clients that are living in homes with the other spouse, and things are getting really uncomfortable. And maybe there's a lot of arguments. Maybe it's just silence and it's uncomfortable. Or there's just kind of some toxic activity that's going on. And our clients ask us, can we get them out of the house? Can we kick them out of the house? The short answer is no. And what we're talking about is a exclusive possession of the marital residence. In order to get exclusive possession of the marital residence, a judge has to have a hearing. And again, that's where there's testimony, there's evidence, and you have to prove to the judge that is a very serious situation. And if both parties continue being in the house, it's going to do like permanent psychological damage to one of the parties or to the children, and that there's no other way to resolve this. A lot of times a judge will just be like, you guys just need to separate and stop talking to each other and just kind of cut it out. A judge, as you can imagine, is not going to easily dispossess somebody of their house. It's just as much their house as it is your house. And so judges don't take lightly kicking somebody out from their home.
Yeah. And, on the flip side of that, Bobby, I'd love for you to talk about, so let's say you're in this situation and you can't kick someone out of the home. But if you made the decision to leave the home yourself, what repercussions are there for you later in your case?
Yeah, if you decide to leave, this is a really great question, thing to talk about. If you decide to leave and you don't take the kids, because ultimately there has to be an agreement there for you to take the kids. If you don't take them, then you can put yourself behind the eight ball as far as your custody case goes, because all of a sudden you become the non-primary parent. The other parent is going to have a lot more leverage as far as negotiation, and it can be really difficult. Now, as we talked about earlier in this episode, we can come in on a motion for a temporary parenting time order and fix some of that, but it's hard to undo sometimes the momentum that you've given the other side, because maybe we don't get in front of the judge for 4 months. And for the last 4 months, the other parent has been doing all of the, waking the kids up, getting them to school, bringing them home, doing the dinner, doing the bedtime. And then the judge is saying, well, I don't want to disturb that. The kids are doing well with this scenario. So you got to be really careful when it comes to moving out without the kids. We recommend don't do it unless you have an attorney that's involved and you've really thought through the pros and cons of it.
Yeah. Yeah. It's definitely something you really need to consult with your attorney, because it can have some consequences, it sounds like later on in the divorce process. So that makes me think, when you do get to that point when, you are trying to get that temporary order, what type of things is the judge looking at to decide who is potentially going to take possession of the home?
The judge is going to look at a lot of different factors. The main factor, though, is really who is the one creating this toxic environment. And I say toxic, but it really has to be beyond that. It has to kind of be beyond the pale. Now, if it's usually in these cases where we're thinking about exclusive possession of the marital residence, oftentimes there's a better mechanism to do it. And that mechanism is an order of protection. Like if it's so bad that you need to have exclusive possession of the house, it's usually related to there being some element of domestic violence or something like that. And if there is domestic violence involved, then we're using a different area of the law, which is called an order of protection. And if you have been abused by your spouse, then judges are much more quick to give you exclusive possession, to make sure that you're safe, to make sure that the children are safe. So it really comes down to, is there abuse going on? Now, judges can do it without there being abuse as defined by the law, but it has to be really close to that. It has to be something that's ongoing if it's not abuse. Now, abuse, one event could do it. And you can take advantage of the order protection law. But if there's not abuse, it has to be something usually that's going on and on and on and doesn't look like it's going to stop and is causing psychological harm to the kids, and the judge needs to break it up.
So, Bobby, let's say your client has gone through the process and has a temporary order. So now we've got to talk about the importance of actually complying with these temporary orders, why that's important. And then, maybe what happens if your ex-spouse is not complying, and maybe some possible remedies of how to fix that.
Yeah, so if you don't comply with a temporary order, what can happen is you could be subject to a finding of contempt. You could be subject to paying the attorney's fees of the other side, and then some sort of penalty or some sort of makeup order in order for the judge to resolve what you didn't do or what the other side is owed. What type of remedy is appropriate here and what to do if your spouse isn't following the order is going to depend on what type of order it is.
Well, and I imagine, if you're getting ready to go into a court case, I would think it'd be best to mind the orders, right? Because if you're not, doesn't that look really bad to the judge?
Yeah, absolutely. One of the biggest reasons to mind the orders and follow them to a T is because this is a human process, and there are people that are judging you throughout this process and making decisions on, especially if we're talking about custody, if you're the type of person that can't follow an order, then a judge is going to naturally conclude that you're probably not someone who can very easily co-parent. So just following the orders in order to maintain goodwill in the case is incredibly important.
Yeah. And you said that, there are some ways that you can enforce it, but I imagine they're expensive in addition to the judge not being happy with you.
Yeah. And unfortunately, if your spouse doesn't follow the order, let's take, for example, and we'll do two different examples. One, they're not paying child support. What can you do? Well, the first thing is, it doesn't make a lot of sense to try to enforce it if they're just a few days late paying the child support. Like, I hate to break it to you, but they're going to get away with that. And that's just kind of going to be something that's a nuisance rather than something that makes sense to really litigate in court. If they're just entirely not paying it, though, that's when your attorney can bring what's called a petition for rule to show cause. And that's an old-timey legal expression that basically says, I want the other side to come to court and explain why they're not following your orders, judge. And so we put in that request. Now, that whole process of getting that heard again is as slow as getting the initial order. So it might be a few months until you're in front of the judge. So now you've gone another few months without getting any support, that financial support. Now, once you do get in front of the judge and he hears what's going on, you're most likely going to get a pretty swift contempt order from the judge. And the judge is going to say, okay, I see that you haven't been paying the support. You don't have a good reason not to pay the support. I'm going to find you in contempt. You have to purge yourself of that contempt, meaning you have to basically make things better by immediately paying this person $3,000 or $5,000 or whatever you owe. And if you don't, I may put you in jail. So that's really, that's ultimately, there's carrot and there's stick. And the biggest stick that the judge has is, I'm going to lock you up if you don't follow this order. And that's the most cut and dry type of enforcement. It can get a little bit more complicated, as you can imagine, if the other parent, for example, is not giving you the parenting time that you were ordered. A judge isn't necessarily going to put them in jail for doing that. And judges in general don't like to put parents in jail either, because the biggest person that suffers is the kids when someone is locked up in that way. Now, for 99% of the people listening to this video, they're never going to get close to either spouse going to jail for non-compliance of an order. But I think it's important to understand, like, that is ultimately where this can go, if you don't follow orders or the other side doesn't follow orders. But it is a very lengthy, very contentious, can be expensive process. And so we try to avoid it whenever possible.
Yeah, well, gosh, I mean, hearing you say that, I mean, when you think about divorce, you don't often think about one of the spouses being thrown into jail. So that, I mean, that does get pretty serious, when it comes down to it. Because you're not really in that mindset. I feel like that, anyone's going to actually go to jail over this. But, if you aren't doing what you've been told to do by the court, it could end there. So you have to also remember that this is a big deal, that you are in court. And I certainly don't want to end up there. Well, we have talked about a lot today, Bobby, and with the temporary relief, there's the temporary order, there's the emergency order, and then also that immediate relief. And kind of as I think through our conversation, the things we mainly talked about were figuring out, the kids, if you have children, what is that plan going to look like? Also, the finances. What does the financial situation look like during that time? And then also your home and who's going to be there and who has, or both of you going to be there during that time. What are some of your takeaways from today that you want to make sure that people remember?
Well, I think the number one thing to realize is that the temporary order process can be slower than you usually need it to be. So we want to kind of prepare for that and be ready and not have this expectation of like, oh, if things go sideways in my case, I can run to the courthouse and the judge is going to fix it. It really doesn't work that way. So when it comes to the financial aspect, you kind of need to be planning in the background if you think that's going to be an issue. For example, some of our clients have to squirrel away money for a few months or longer to make sure they have a little bit of a safety net when they do start this process, if they're cut off financially, or they need to start getting their family members prepared for that. And we also want to think about, how are we caring for our kids during this lead up to the divorce process? Because the judge, the GAL, the other side is going to be looking at whether or not we are acting as a primary caretaker. Don't ask to be a primary caretaker if you're not acting as one. I think those are the two biggest takeaways that listeners can use in order to really prepare themselves for what's going to happen in the court process.
Yeah. And I think it's always a great reminder to, that the best is always to decide on their own for the two spouses, ideally to come up with those plans, because that would be the fastest way to come to an agreement, would be the two of you, like we've talked before, over the kitchen counter at the table, just deciding. But obviously, like you said, it can take a lot of time. And I was kind of wondering, if you have some of these temporary orders and they go into place and they seem to work well for the kids, do you commonly see that at the end of the court case, at the ruling, that some of those things may be similar as far as the custody timing and then some of the financial situation?
Yeah, absolutely. And that's one of the reasons that these temporary order hearings can be so impactful and important, is because what the judge does decide or what the parties do agree on during the temporary order process can have a lot of standing power. And usually what the parties will do is they'll say, okay, this is working, but we want some tweaks here, we want some tweaks there, but it will set the foundation for further negotiation. So it's very important to recognize that might happen.
Yeah. Well, Bobby, as always, thanks so much for all of your insight today. And before we go, I would love to, we've got a question of the week. So this is not about the topic we're talking about today, but I was walking with a friend this week and her sister is going through a divorce. And so I wanted to know, she was worried about her sister because her spouse won't sign the papers, right? Will not agree to get a divorce. So what happens in that situation if one partner is done and they want to get the divorce and the other won't sign on it? How does that work?
That's a great question, and something that's can be really frustrating, because you've you've done all the legwork, you've done the heavy negotiation, you've done maybe a hearing or 2 or 3, maybe even you have a GAL that's gotten involved and made recommendations, and you've finally gotten to the place where there's an understanding on what this agreement is going to be. And their attorney goes back and drafts it, or maybe yours does, and now we're just waiting for signatures, and they will not sign it. So you have a couple options here. It's going to depend on where your case is in the process. One of the options is to just set the case for trial. And by setting it for trial, you create some really hard deadlines that force the other side to do work. So basically, they'll be put in a box where it's really like, okay, if you don't want to sign it, then your attorney is going to have to start doing a lot of work. And before you know it, you're going to start getting attorney's bills for their time. So either we sign this and get it done, or you're going to start getting invoices from your lawyer for thousands of dollars preparing for trial. So that's one method. The other method is kind of just the waited out method. And that's a lot of time what I do recommend is in these situations, people have a hard time bringing these things to a closure. It's very emotional. They're going to sign it, but they just need a little bit more time. I know you're anxious, you want it signed, but we don't want to poke the bear. We don't want to do something litigation-wise that pisses them off, and now they dig their heels in even more. So let's just be patient. We know we're going to bring this over the finish line, but let's just wait. We know it's going to be done. So that's usually the first recommendation that I have, because if we set trial deadlines, then it's not just the other side's attorney that has to do work, it's your attorney too.
Right.
And that's kind of a lose-lose. So rather than that, it's more, I just preach patience. Let's see what happens. Let's give this another 30 days, 60 days. I know you really want it done. It's going to get done. Just please be patient with me and we'll get through this. It's a tough spot to be in. There's no perfect answer, but more than anything, we don't want to disturb the agreement that we have, and being very delicate and diplomatic during this time, I think, is the strategy that wins.
Yeah. Okay. Well, that is great advice, as always, Bobby. Well, thanks so much for being here with us today. We always appreciate all of your helpful advice and walking everybody through this, what can be stressful divorce in easy to manage steps.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.